A very good morning to very good afternoon to one and all. Okay, so I just hope that you all remember whatever we have discussed in the last class. Everybody, did you go through? Okay, understood everything properly? Let us just brush up everything once again. Okay, so you now tell me what have we discussed in the last class? We started with what? The Indian Contract Act 1872. I told you there should not be anything missing in the name of the act. How the act is to be said? The Indian Contract Act 1872. Okay. So what have we seen in this act? Yes. We have started with proposal first. Okay. Before that you did not study anything. What is section 1? Section 1 always is what? Short title, extent and applicability. Very good. What is the short title? What is the name of the act? Obviously, the Indian Contract Act 1872. And what is the extent? It extends to whole of India. Applicability? 1st of September 1872. This is the section 1 of the act. Then what did we discuss? What is section 2? Definition. What is the definition? What definition? What is that you mean by definition? Yes, meanings given in your legal terms. Okay, the meanings not in your normal common meanings which is given your dictionary meaning. It is definition. It is the meaning in your legal terms. So what are the definitions that we have seen? What is the first definition that we have seen? It is given in which section? Clause A of section 2. I want any one person to tell me the definition. Who is going to say? Come on, you can see and say also, not a problem. Come on, loudly. Such act or absence. Clear with this? Okay, second definition. Promise. It is given in which section? Clause B of section 2. What is the definition? Who's going to tell me that? Come on, raise your hands. Yes. It becomes a promise. Okay. Now then next what is that we have seen? Agreement. Who's going to tell me the definition of agreement? Come on. For each other is an agreement. Understood with this also everybody? You remember the example also everybody? Okay. Did you make a note of that example? Yes or no? Okay. And then what we have seen which contract. What is the definition? Which section? Clause H of section 2. So what is the definition? Enforceable by law is a contract. Okay, so we have seen these definitions till now. Now we have also कहाँ पर recharge? Okay. Okay, so we have seen the definitions. These four definitions we have seen. So in contract, what is that we have seen? What is a contract? An agreement enforceable by law. Now, did you see the difference between agreement and contract also? Did you understand? Now, I want any one person to tell me the differences in your own words. In your own words, you can tell me the differences. Okay, you can, any one person can say one difference, other one will say another difference, whatever you remember. Come on, tell me, who's going to tell me the first difference? Not in sequence, whatever you remember. Come on, fast. What is the difference between the agree? Yeah. Well, by law, very good. This is nothing but the definition. Okay, the difference between of the definitions. And next one, who's going to tell me? Yes, narrow concept. Concept. Very good. Next one. All agreements. Very good. Okay, all agreements are not contracts, but all contracts are agreements. Anything else? One more difference. Come on, come on. Yes. Yes. In agreement may or may not create legal, may or may not. But in agreement, in contract, compulsorily there is legal obligation. Clear with these differences also. And in short, what is that? What is agreement? Offer plus acceptance is your agreement. Okay, clear with this, everybody? Yes or no? Okay. Now, what were we discussing now? We have, yes, let us come to that point now. Clause H of section 2 is giving the definition for contract. As per your clause H of section 2, contract is nothing but an agreement which is enforceable by law. An agreement which is enforceable by law. Now, in your last class, I think you're clear with what is that you mean by agreement. And you're also clear that if it is an agreement, you cannot say that it will definitely be a contract. It can be an agreement, but it is not a contract. Why? What is missing in that? Enforceability of law is missing in that. Yes or no? And now, you tell me, what is that you mean by this enforceable by law? Support of law, force of law, backing of law. Law is giving you that support. Okay, you enter into contract. If something wrong happens with you, I will help you, I will support you, I will be at the back of you. So you enter into contract. If that support is given by law, then it is always a contract. That type of agreements are always considered to be legally enforceable, therefore they are only contracts. To those contracts where you don't have support of law, that means they are not enforceable by law, then that is only an agreement, but that is not a contract. Okay, so say if you have entered into agreement, in this agreement now there are some important essential elements which are required to be present. There are some essential elements which are required to be present where in the agreement. If these essential elements are present in the agreement, then only this agreement will be what? Enforceable by law. And I already told you before that the essential, how many essential elements are there in total? 10 essential elements, that is given under section 10, and those which are not given under section 10. Yes. Given under section 10 means what? Obviously it is given in your Indian Contract Act 1872. Not given under section 10, generally it should be there, or by some case law it should be there. So totally you have how many? 10 essential elements. Any one essential element is missing means what? It is not a contract. It is not enforceable by law. Okay. Now let us now come to all these essential elements. Okay. Now essential elements, whatever we are going to see now, are just, what do you say, just briefly I'm going to tell you now. Why? Because in your further units, these essential elements are going to be discussed in detail. Your unit 3 is all about all the essential elements. So in that we are going to discuss in detail. Now at present I'll tell you briefly what it means. Okay, come on, let's start that. First let us see essential elements given under section 10. Essential elements which are given under section 10. First one, two, sorry, no. Actually, let us see first essential elements not given under section 10. Okay, not given under section 10. So in this first is two parties. But obviously, say for example, I have this pen. Can I sell this pen to myself? Is it possible? Yes or no? So is it possible for a person to enter into contract with himself? Obviously there has to be at least two parties. Minimum two parties. There can be more parties also, 3, 4, 5, 6, many parties. But at least there has to be two parties for you to enter into contract. Obviously you cannot enter into contract with yourself. If you say, okay, I have this pen, I want to sell this pen to myself, then is it a contract? No, it is not a contract. It is an agreement with yourself. You have agreed something with yourself, but it is not a contract. Why? Because obviously, will court support it? No. What is that? Entering into contract with yourself. Is there any meaning in that? Is there any sense in that? Obviously not. Understood? So, in a contract, compulsorily there has to be at least two parties to enter into contract. At least two parties means what? Minimum two parties. But there can be many parties. 2 or 3 people are, say I have a car, okay, and there are few neighbors. I have some neighbors, okay. 2 3 people are my neighbors, and they all want to use the car together. So I can sell the car to 3 people together. Or a house, say I have a house where I have 5 6 rooms. Can I sell that house to 2 3 people if they agree? Obviously. So I am entering into contract with another 3 person. Is it a valid contract? Yes. There has to be at least two parties minimum, but there can be more parties also. But minimum there has to be at least two parties for an agreement to be a contract. For an agreement to be enforceable by law, there has to be at least two parties. Okay. Now there was a case law which because of which this point came into picture, okay, which has supported this point. State of Gujarat versus Ramandal S&C Company. State of Gujarat versus Ramanlal S&C Company. This is how generally case laws are denoted. Who are the two parties for this case? One is State of Gujarat. That is nothing but why State of Gujarat is given here, because a sales tax office. There was a sales tax officer who wanted to impose sales tax on a partnership firm. And what is that partnership firm? That is Ramanlal S&C Company. You know, right? What is a partnership firm? What is a partnership? Anyways, in your third act, which is the Indian Partnership Act, we are going to see what is that. But I think you have an idea of what is a partnership firm. Everybody. Yes or no? So what is a partnership firm? When few people, they decide to come together and do business, that is nothing but partnership firm. They are doing a business as partners. Now you tell me, partnership firm and partners, they are one and the same or two different parties? You have studied this in your intermediate. essential characteristics, features of partnership. In that, I think everybody have studied it, that partnership firm and partners are one and the same. They are no two separate parties. But in case of companies, company is a separate person and the shareholders are separate person. The members of the company are separate. Both are separate. But in partnership, is that the case? No. Both are one and the same. Yes or no? So what happened? Ramanlal S and company went for dissolution. You know what is dissolution? They wanted to now stop, close down their business. Okay. Now in business, obviously you have assets, you have furniture, you have machinery, you have building. Assets are there. Those assets are whose assets? Firm's assets. In other words, they are firm's assets as well as partners' assets jointly. Say there are three partners jointly. They are partners' assets also. Now on dissolution, what is that generally they do? They keep the assets as it is or they sell off the assets. They obviously sell off the assets. Yes or no? When in this Ramanlal S&C company, they went for dissolution. So what were they doing? They were selling off the assets. Okay. When they were selling off the assets, obviously they'll earn some profit. Sale proceeds will come. Okay, profit as well as sale proceeds will come. Now those sale proceeds were were distributed, divided among the partners. All the partners took as per their ratio. They have taken the sale proceeds. Now what did the sales tax officer do? The sales tax officer said that because there is a sale, now you got the sale proceeds, now I will impose sales tax on you, as well as I will impose sales tax on the firm also. Can he do so? No. The sales tax is to be imposed only on the firm but not on the partners personally. It will go in the expenses of the firm. Yes or no? So in this case, then there was a dispute. Sales tax officer said to partners, partnership firm will have to pay me sales tax as well as the partners. Why? Because lump sum amount is, who is getting the lump sum amount? Firm. But again, who is getting the contribution? Partners. Now he's saying that on that contribution also you pay me the sales tax. But these people said what? Firm and the partners are one and the same. Yes or no? So can there be any sale between the firm and the partners? What did the sales tax officer said? No, there is a sale. The partnership firm is selling you. You got the proceeds. Now you will have to pay us the tax. But in this case, the court gave the judgment that partnership firm and partners are one and the same. So can there be sale between the same party, one party? No, there has to be at least two parties. Got this point clear, everybody? Yes or no? There has to be at least two parties for an contract, for an agreement, for a contract. There has to be at least two parties. Got this point clear? So that was the case law, and in this case, the case was decided in the favor of Ramanlal S and company, and therefore the sales tax could not be imposed. Clear with this? Yes or no? Everybody? Okay. Second essential element. Intention to create legal obligation. Obviously, this is the main point which we are discussing. Yes or no? Intention to create legal obligation. Intention means what? You're intending, you're wishing, that is the purpose for which you're entering into contract. That is your intention to enter that. If this person says a no, if this person afterwards says a no or does not perform the contract, then I will take this person to the court of law. Okay. Yes or no? Will you say that? Will you think about that when you enter into contract? Then only it is a contract. Otherwise, it is not a contract. So, whenever parties enter into contract, there should be an intention to create legal obligation. There should be an intention that if something wrong happens to me, I will take the other person to the court of law. Is this possible in case of your social agreements? Is this possible in the case of your domestic agreements? It is only possible in case of your legal agreements. If I'm inviting you for dinner, you're not coming for dinner. But when I'm inviting you for dinner, when I gave that proposal to you, was my intention that if my friend doesn't come to my house for dinner, I will take my person to court of law? Was that my intention? So when I am giving that proposal, so am I thinking that I will take this person to court of law? No, therefore I am not creating any legal obligation. Therefore it is not a contract. Or else I'm inviting you for dinner. Okay, you said a yes to me. Okay, now when you said a yes to me, did you think saying yes, whenever you said a yes, did you think that if this person does not prepare dinner for me, does not make any arrangement for me, I will take this person to court of law? Did you think that? Obviously not. So both the parties, are they having any intention to create legal relationship here? No, it is just a social relationship. Yes or no? That is the reason it is not a contract. Why? Because the intention behind the proposal, intention behind the acceptance is not to create any legal relationship. Therefore, no contract. Got this point clear? Here also we have a case law. That is nothing but Balfour versus Balfour. Now you must be thinking, Balfour versus Balfour, both are same parties. How are they getting in, how are they entering into contract with each other? Yes or no? It is just the surname. Surname are same. Why? Because they are husband and wife. Okay, so that is the reason the case law is how Balfour versus Balfour. Okay, so how was the what was the case in this? Husband promised wife that I am going abroad. Okay, I have some work, so I am going abroad, but I will give you the maintenance money. Say pocket money to, anyways he is only seeing all the expenditure, but any extra just as a pocket money for you to expend, I will give you that money. Okay, but he was giving that money, due to some problem for few years he couldn't give the money, so he did not give the money. Now wife went to court of law and filed a case against the husband, saying that he promised me to give that money and now he is not giving me the money. In this case, they are husband and wife. They are husband and wife. Obviously, expenditure will be taken care by the husband only. This was just an extra money which husband promised to give to the wife, which he couldn't give for some reason. Okay. Now in this case, the court decided the case in the favor of husband, saying that whenever husband promised and wife accepted, there was no intention of creating any legal obligation. It was just a domestic contract. Got this point clear? It was just a domestic contract. I gave you the proposal, I will pay you the money. You said yes. There was no intention that if you don't pay me, I will go to court of law. There was no intention of creating any legal obligation. There is not a contract. Therefore, no punishment was given to husband. Got this point clear? So, in any contract, it is very important that when you enter into contract, when proposal is made, when proposal is accepted, that time the intention of the party should be to create any legal obligation. If that is not the case, then no contract. Clear everybody with this? Yes or no? That is only this case, Balfour versus Balfour. In this case, you can take that example also, social agreement example which I told you, the friend inviting for dinner, or that example also will come here. Say if I'm promising, husband is promising to give her the gift a diamond ring, or say father is promising son or daughter that if you clear your CA, I will give you a new mobile phone, but he couldn't give. Then will you take your parents to court of law? Obviously not. If you don't clear your CA, will your parents take you to court of law? Obviously not. Was that the intention when agreement was made? No. Yes or no? Don't worry, no one will take you to court of law, but you have to clear. No one will take, but I will do something that that is very dangerous than court of law. Okay? You have to clear, so you have to work hard. Okay? Clear with this, everybody? Okay? So this is the second one. Third one. Other formalities to be complied with. Okay. What is the next one? Other formalities to be complied with. See, generally, there is no in your Indian Contract Act, there is no compulsion that the contract should always be written. You know, when you board a bus, when you board a bus, there is front upper side of the bus, it is written Sikandrabad, and all the places are written. So you know that when you board that bus, you are going to be taken to that place. So you board a bus because you want to go to that place. You buy a ticket, then the driver, the conductor will also know that there is a contract that we have to take this person to that place, and the person will pay us the money. Is there any agreement now? Yes, there is an agreement. There is actually a contract, legally binding contract. Yes or no? It is a contract. Now here, is there any contract which is in writing? Do you write something and give it to the conductor? Please take me to this place. Or they are going to write yes, yes, signing. Is there any formality required? No. But is it a valid contract? Yes. You go to a grocery shop. You want to buy some, say, some items, say some food items, or some essential items, day to day essential items you want to buy. So do you enter into agreement with that shopkeeper in writing? I want these things, I will pay you this much money. Then shopkeeper, is there any written agreement? Obviously not. But is that there a valid agreement? Yes, it is also contract. Say, or every day we enter into contracts, you know. Every day we enter into small contracts. You go by auto, you go by bus, you go to a movie to watch a movie, you buy the ticket. All these are nothing but contracts. Obviously, say for example, if auto driver don't take you to that place, stops in between, you can take that person to court of law, but we generally don't do. Why? Because we have a lot of time, we don't want to waste the time. But there is actually a valid contract here. You are entering into valid contract. Got this point clear? Every day in small things you enter into contracts, and those are very much legally binding contracts. Okay. So why? Because small things, 10, 15, 100 rupees are involved. Why will we go to court of law and expend thousands and thousands of rupees there? Obviously not. Yes or no? So we ignore those things, but they are also valid contracts only. So in Contract Act, nowhere it is written that the contract should be in writing only. Contract should be signed by the parties only. Contract should be stamped. All these things are not written in your Contract Act. Okay, but there are some contracts where it is very important that some formalities is to be complied with. Say for example, if you want to purchase and sell any immovable property, land, building, compulsorily that should be in writing. Compulsorily that should be signed by both the parties along with the signature of witnesses also. It should be stamped by proper stamping authority also. Then only it is a valid contract. Contracts of insurance, they should be writing. And you have to give all the required details to the insurance company. Health issues are there, or if your factory is at some place where there is cyclone, floods coming, or there's dangerous situation, you have to give all the details to your insurance companies also. It is to be in writing, it is to be signed by both the parties also. Okay, so in this point, other formalities to be complied with, it is being told that if any contract requires some formalities to be complied with, then you should comply. If there are no formalities required, no, don't comply with any formalities. But see, I am entering into contract with, say, what is your name? Dipali. I am entering into contract with Dipali to sell my house. It is in mobile property, yes or no? So I want to sell my house to Dipali. But orally only we entered into contract. Dipali, I will sell you my house. You pay me 20 lakh rupees. Orally only we entered into contract. Is it a valid contract? If say I afterwards, after giving proposal, after Dipali accepting, I am now saying I don't want to sell you my house. Can she go to court of law against me? No. Why? Because this was not a valid contract. Why? The formalities were not complied with. Because the formalities were not complied with, it is not enforceable by law. For this contract, it was important to be in writing, to be signed by the parties, to be signed by the witnesses, all the terms and conditions to be mentioned, and to be stamped by the stamping authority also. Got this point clear? Yes or no? So this is the point which is being told here, that other legal formalities, if any, why? Because it is not compulsory that all contracts will have legal formalities. If any to be complied with, comply with it. If you're not complying with it, then is it a contract? It is not a contract. Clear with this? Third point also, everybody, yes or no? Okay. Fourth one. Certainty of meaning. Certainty of meaning. Certainty of meaning is nothing but clarity in the meaning. Clarity in the meaning. What is that you mean by certainty of meaning in this case? Contract act. See, whenever you enter into contract, you have many terms and conditions. I will sell you my red color car. You will have to pay me a price 5 lakh rupees in cash, down payment of 1 lakh rupees. There are many terms and conditions which are given between the parties. Yes or no? So here, what meaning should be clear? The meaning of those terms and conditions should be clear. I am giving you a proposal. I should be clear with whatever I am saying. You are saying a yes. You should be clear with whatever you are saying. So, I should understand whatever you have told me. You should understand whatever I have told me clearly. Clarity of meaning. Then only it is a contract. Otherwise, it is not a contract. Say, for example, I am going to an oil shop to purchase oil. So in that oil shop, that oil shopkeeper is selling groundnut oil, sesame oil, and coconut oil, many various types of oil. I am going to the shopkeeper and I am telling, please give me 5 liters of oil. And he is packing some oil and giving me. Afterwards, if I am saying, no, no, this is not the oil I wanted something else, then will that be valid? Can anyone go to court of law in this case? No. Why? Because what was missing here? Certainty of meaning. Was I clear to which oil I wanted? No, I should specify that I want 5 liters of coconut oil. I want 5 liters of groundnut oil. Then only there is a valid contract. Okay, vague agreements without any meaning agreements, if you enter, then it is not a contract. Say for example, I am telling you, I will sell you my car at a price which I wish to on Sunday. On Sunday, I will think about some price and I will sell you that car. So, is there any certainty of meaning or there is some doubt in your mind? There is some confusion, there is some doubt in your mind, yes or no? Is there is clarity of meaning in this contract? No. Therefore, it is not a valid contract. Once I am clear with the price, once I tell you the price, then only the contract will come into existence. Till that time, no contract. I gave a proposal, you also said a yes, but there is no clarity of meaning. There is confusion in the mind of parties regarding the terms of the contract, not a valid contract. Clear with this? Yes or no? So that is what is that you mean by certainty of meaning. Next one. Possibility of performance. Possibility of performance. Obviously here possibility of performance means what? It is humanly possible to perform. Whatever you are entering, whatever you are agreeing, whatever contract you are entering, it should be humanly possible to be performed. If I tell you that I will pay you 5 lakh rupees, please walk to the moon. Can you do that? Walk to the moon. Now you go and walk to the moon. I will pay you 10 lakh rupees, 5 lakh rupees. Is it a valid contract? Is it possible to be performed? No. I gave you 5 lakh rupees, but you did not walk to the moon. Can I go to court of law? See, I entered into contract. This person did not walk to the moon. What will court do? Mental asylum. This person should go to mental asylum. Yes or no? So, whenever you enter into contracts, it should be possible of performing. There should be possibility of performing that. Otherwise, it is not a valid contract. If I tell you, I will pay you 50,000 rupees, write 100 pages in 1 minute. Come on, do it fast. Can you do it? Yes. Yes or no? Who can do it? One minute, full 100. No, you cannot say tick, 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 tick. See, I have completed 100 pages. Entire page you have to write in 1 minute. Can you do that? No, not humanly possible. Yes or no? Therefore, it is not a contract. Clear? Because there is no possibility of performing it. So whenever you enter into contract, the contract, see, whenever contracts are nothing but it is based on performance only. One party is doing something, other party is also doing something. I am giving my bike, say you will pay me 1 lakh rupees for my bike. Yes or no? I am going to sell you some bags of rice, you are going to pay price for that. Okay, I am a carpenter, I am coming to your house to repair something and you are going to pay me price for that. So in contracts there is performance. Both the parties are performing something or the other, they are performing. Yes or no? So in this performance, whatever performance you are doing, that should be possible. If it is impossible, then not a contract. Here impossibility means humanly impossible also and legally impossible also. Legally also, if it is impossible, what are the things which are legally impossible? Say murdering someone or robbing someone, all those things. Maybe you are saying I can do that, but is it legally possible? Legally, is it possible? No. Why law is telling you you should not do it? Legally impossible. Humanly impossible, legally impossible. It is not a valid contract. Clear with this, everybody? So, possibility of performance. So, not given under section 10, did you understand what are the essential elements for an agreement to become a contract? In agreement, what is to be present? Obviously, there has to be at least two parties. In an agreement, there has to be always intention of creating a legal relationship. In an agreement, if there are any formalities which are required to be complied with, you should comply with those formalities. In an agreement, terms and conditions of the agreement should be clear. There should be certainty of meaning. In an agreement, there should be possibility of performance. If these are present, then only it is a valid contract. Okay, these 5 things which are not given under section 10. Now we are going to see under section 10 also. Say for example, there are two parties, there is intention of creation of contract, certainty of meaning is there, possibility of performance is there, but formality is not complied. Then is it valid? So all the 5 are to be complied with or not? Yes. Okay. Sure. Now let us see essential elements given under section 10. First one, offer and acceptance. Obviously, how is that you make an agreement? There has to be offer, there has to be acceptance of that offer, then only it is an agreement. Without offer and acceptance, will there be any agreement? No. But here, what is that they are talking about? Offer and acceptance should be proper offer, proper acceptance. Then only it will be valid contract. Now, you will get a doubt now. How will we know what is a proper offer, what is a proper acceptance? That is also given in law. Now we are going to further when we are going to see offer. In offer also again you have essential elements of offer. If those essential elements are present in offer, then only it is considered to be a proper offer. Acceptance also again we will see what? Essential elements of acceptance. If these essential elements of acceptance are present, then only it is considered to be a valid proper acceptance. So here this point is saying what? There has to be not only offer acceptance, there has to be proper offer which is valid under law, proper acceptance which is valid under law. Then only there will be a contract. Otherwise there will not be any contract. Clear with this? Okay. Now, next one. Second one which is given under section 10. Free consent. Free consent. What is that you mean by consent? Agreeing to something, saying a yes to something. So, in any agreement, do we require this yes? Who will give this yes? The person who is giving the acceptance will say a yes. So whenever a proposal is given and that proposal is to be accepted, that acceptance should be free. Free here means what? There is no force. Forcefully you cannot tell that person, come on, say yes, say yes. No, there is no force. Now, law is only telling you this is something which is in depth covered in your unit 3, other essential elements of a valid contract. Now I'll tell you briefly why, because if we go in deep into this, it will take a lot of time. There obviously we'll have to see each and every point deeply. So briefly I'll tell you just brief meanings of everything. Now when the contract is considered to be free consent, when the contract is considered to be free of consent, okay, when it is entered without applying coercion, without applying undue influence, without applying any fraud, misrepresentation, and mistake. So these, if any contract is entered without coercion, without undue influence, without fraud, without misrepresentation, without mistake, then only the consent is free. Otherwise, if you have coercion, not free. If you have undue influence, not free. If there is any fraud, not free. If there is any misrepresentation, no free consent. If there is any mistake, no free consent. Apart from these, all are considered to be of free consent. Now, what is that you mean by coercion? Coercion is nothing but it is threatening to harm somebody. Coercion is what? Threatening to harm someone is nothing but coercion. Say, for example, I am telling you, I want to sell my house to you, which is worth 10 lakh rupees. I have a house, I will sell you my house, which is worth how much? 10 lakh rupees. But you will have to pay me how much? 50 lakh rupees. Come on. I will sell you my house, you pay me 50 lakh rupees. I am having a gun, I am keeping that gun on your head. Under that gunpoint, I am telling you, come on, sign the contract. Take my house, pay me 50 lakh rupees. Then, obviously, what is that you think? What is that you'll do? You will obviously say, yes, 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 I will sign. Wherever you say, I will sign. Come on, tell me. You will sign. Have you entered into contract? Did you say a yes to this contract? But there was a threaten to do some harm. Yes or no? So what was applied here? Coercion, therefore no free consent, not a contract. Now if you don't pay me 50 lakh rupees, then can I go to court of law? Will court support me? Yes. Court will put me behind the bars. Why did you use the gun? Why did you use that gun to on that person? Yes or no? I will go behind the bars obviously. Yes or no? Okay, so whenever any force is applied to enter into contract, it is not a contract. No, 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 that is what I'm telling you. No, he is accepting, obviously I'm telling here, he is accepting. After acceptance also no contract, there is agreement. I am also telling purchase my house, you are also saying yes, yes, I will purchase, but you are saying yes under what? Under that pressure. Yes or no? There is an agreement here. Agreement means what? Both the parties are saying yes, but why there is not a contract? Why there is no support of court? Why? Because there is no free consent. Yes or no? Here, that is what is given here. In all these cases, both the parties are saying a yes. But one party is saying yes, what? Under force. One party's yes is given under force. Agreement is entered, but is it contract? No. Why it is not a contract? No free consent. Was this point clear? Yes or no? Undue influence. Undue influence means what? See, another name for coercion is what? Physical pressure. Physical pressure. Physically you're harming someone. Physically you're pressuring someone. See, in detail again we'll see. Don't worry if you don't understand. If you understand little bit also, that is fine. I just hope you have understood it. Yes or no? In deep we'll see in your third unit also. This generally coercion, it can be applied on third party also. Say, I am entering into contract with you. Okay, I am telling you that you purchase my house at 50 lakh rupees. But that gun I am not pointing on your head, I am pointing on your wife's head, on your son's head, on your daughter's head. I am telling that if you don't sign, I'll shoot this person. Here, coercion is applied on you or on some third party. Third party, then also it is coercion. Got this point clear? Coercion can be applied on the person to the contract or to on some third party also. Then also it is coercion. Why? Because the other person from whom we require the consent, that consent is not free. There is some physical pressure you are applying. Okay? Yes or no? Got this point? Coercion, everybody? Undue influence is nothing but it is moral pressure, or you can say there is some moral pressure or some mental pressure. Moral or mental pressure. Generally, this happens undue influence between the parties who are having some sort of relationship. Between the parties who are having some sort of relationship, and relationship is such where one person is dominating, other person is being dominated. Say for example, master and servant. Master is dominating position and servant is in a weak position, dominated position. Or for example, doctor and a patient, where the patient will think whatever doctor says I will listen, then only I'll be cured. So the doctor is in a dominating position and patient is in dominated position. So generally undue influence happens only where there is some relationship between the parties. And what kind of relationship between the parties? Where one person is dominating, another person is being dominated. Say for example, the master is saying to the servant that your bicycle is very nice. You give me your bicycle. Now the servant is saying that master, my bicycle is worth 5,000 rupees. No, I will only pay 1,000 rupees. If you don't give me your bicycle at 1,000 rupees, then I will not keep you for the job. I will fire you from the job. Yes or no? So because of that position, that relationship, now the servant is saying, no, it is better that if I say yes, I will say a yes to the contract. So here the relationship is influencing the contract. Got this point clear? Yes or no? That person is saying a yes, but under some moral pressure, under some mental pressure, that person is saying a yes. That is nothing but contracts entered under undue influence. Say some guru or a devotee, where the guru is saying that you name all your properties in the ashram's name. Okay, give all the properties, then you will attain moksha. You will go to moksha. Compulsorily, you will attain salvation. You will go to moksha. So that person being influenced, that so much influence is there of that guru, he is transferring all the properties in that ashram's name. But is that contract valid? Afterwards, can that person take all the properties again? Obviously, yes. The person whose property is there, that property is actually not transferred. There is not a contract. That transfer was not valid only. Why it was not valid? Because there was no free consent. Got this point clear? Yes or no? Got this point clear? So this is nothing but this is, anyways, there are many examples which we'll see in detail when we discuss undue influence again. Okay? Next is what? Fraud. Fraud is nothing but cheating. When you are cheating somebody. Say, I'll just give you one example. I am having this pen. This pen is actually worth 100 rupees. Okay. Now, you are very fond of imported products. You're keen to buy some imported products. You like imported products. And I know that. I'm coming to you and I'm telling you, see this pen, I bought this pen, it is imported pen, it is worth 1,000 rupees and you take this pen. Now, whatever I said, is that right or wrong? and I know that it is wrong. I know actually it is a local pen which is worth only 100 rupees. But I am telling you that this is imported pen worth rupees 1000. And thinking about that, are you buying that pen? Yes, you are buying that pen. Why? Because you like imported things. And whatever details I give you was wrong. I wanted to do some cheating with you. Yes or no? Why I am doing this cheating? Why? Because I am getting the profit of 900 rupees here. Yes or no? That is the reason I am doing cheating. Now this agreement which we have entered is not a contract. If you don't pay me the money 1000 rupees, can I go to court of law? Obviously not. It is not a contract. No support of law. Got this point clear? Now you must be thinking, no support of law means what? You will also not get the support of law. If I give the pen, I take 1000 rupees, can you go to court of law? Obviously. These type of contracts we'll see in detail. They are known as voidable contracts, where the party with whom wrong is done, that party can go to court of law. But the party who is doing wrong, that party is having no support of court. Okay. Why no support of court? Why? Because court is saying there is an agreement. Both the parties said a yes, but this is not a contract. You again take your pen, pay that 1000 rupees to that person. Why? Because there is no contract only. Got this point clear? Yes or no? So that is what you mean by fraud. Intentionally you're doing something wrong. You know it is wrong, then also you are doing that wrong. That is fraud. Another one is what? Misrepresentation. Misrepresentation is nothing but an unintentionally doing wrong with a party. You are doing wrong with the party. Unintentionally means what? You don't know about it. Say the same example I'll use so that you can get the difference also. Please concentrate, everybody. This pen I am selling to you, telling what? This is an imported pen worth rupees 1000. You like imported pens, you are taking this pen, but I also don't know that this is actually a local pen. I am also thinking the party who sold me told me that actually this is an imported pen only. So I also don't know that this is a local pen worth rupees 100. I am also thinking what? This is a imported pen worth rupees 1000 and I am selling you imported pen worth rupees 1000. So am I doing something wrong with you intentionally? No, unintentionally. Yes or no? This is known as misrepresentation. So law is saying that under misrepresentation also there is no contract. That means the law will say take your pen back, give that 1000 rupees to the other party. There is no contract. The other party, whoever did wrong to you, you can file a case against that party. But between the parties here, there is only what? Misrepresentation. Therefore, there is no contract. Why? Because there was no free consent. Free consent here means what, you know? We already discussed that point. Remember, consensus ad ideum. Remember? Meeting of minds. That is something which is to be present for free consent. Both the parties should think same thing in the same sense. Then only valid. Otherwise, it is not valid. Got this point clear, everybody? Yes or no? Understood what is misrepresentation? Yes or no? So misrepresentation also there is no free consent. Mistake. Mistake is what? Wrongful act. I know that. What did you think? Okay. Okay. Mistake is nothing but wrongful act where both the parties are mistaken about something. Okay. Mistaken about what here? Maybe the subject matter, maybe the consideration, maybe the terms of the contract. We are mistaken about something. Here, you know, if you see here, or mistake if I say, wrong thought, wrong thinking. Okay. Misrepresentation and misrepresentation is done by other party to you, but mistake is done by you to yourself. For this point, got the difference between fraud, misrepresentation and mistake? I am telling you that this pen is worth rupees, actually it is worth rupees 100, but I am telling you it is worth rupees 1000, imported pen. If I am doing fraud with you, in misrepresentation also I am telling you something wrong, but in mistake what happens, you are thinking I am not doing something wrong with you, I am telling you all the details, but you are thinking something which is not right. I didn't tell you anything, but you're only thinking, okay, this pen looks very nice. Maybe it is imported pen. I'll buy this pen for 1000 rupees. Come on, give me this pen for 1000 rupees. I will give you this pen for 1000 rupees. Here, did I do anything wrong with you? No. You are only mistaken about it. So that is mistake. Mistake is something which you think that is wrong. Okay. See, generally, if it is unilateral mistake, one party is at mistake, it is considered to be valid. Bilateral mistake means what? Both the parties are at mistake. Then only it is considered to be not a contract. What is the meaning? There is no consensus ad idem, no meeting of minds here. Yes or no? Do you remember I gave you one example, car example? I have 5 cars. I want to sell you, say, white car. You want to purchase, say, golden car. Yes or no? Yeah, whatever it is, color, white, black, whatever. But here, I am mistaken about something, you are also mistaken about something. Yes or no? How we are mistaken? We are only thinking something which is not right, wrong. That is the reason this type of contracts are considered. Agreements are not contracts because of mistake. Mistakes. They are mistake, wrong thinking, wrong understanding, no consensus at idiom, no meeting of minds. It is a mistake. Got this point clear? Okay. So if contracts are entered under coercion, under undue influence, under fraud, under misrepresentation, or under mistake, it is considered to be not a contract. Anything apart from these, contract. Got this point? Anything apart from these, law is saying that there will be free consent. When there will be no free consent, law is saying when these are present in any agreement, these 5 things are present, then only there will not be any free consent. Otherwise, rest of the cases, free consent. Clear with this? Everybody? Okay. Anyways, I just wanted to give you briefly. So briefly we have seen. I think briefly you have understood it properly now. Okay. In detail, each point, valid, voidable when it is, and what is the when it will be punishable, when it will not be punishable. All these things we are going to see in detail. Who can file the case? Who cannot file the case? In these cases, we are going to see in your third unit, not now. Okay. Now the next one. Capacity to contract. Here, capacity to contract means what? Ability. Ability to enter into contract is nothing but capacity to enter into contract. Okay. You should be having that ability to enter into contract, then only contract is valid, otherwise it is not valid. So as per your Indian Contract Act 1872, the parties who are having capacity to enter into contracts are the parties who have attained the age of majority. That means, can minors enter into contract? No. Law is only telling you minors means what? Below 18 years of age. If you enter into contracts, it is not going to be legally enforceable contracts. It is not a valid contract, not legally enforceable contract, therefore not a contract, just an agreement. So the parties who are entering into contracts should be majors, 18 years and 18 plus, majors. Below 18 years, minors, who cannot enter into any contract. Should be of sound mind. Sound mind means what? Know everything. Is it possible that every person here knows everything? Mentally stable. When you are considered to be mentally stable, when you're considered to be mentally stable, when you can make judgments regarding seeing the terms and conditions of the case. What kind of judgments you can make? Okay, this is beneficial for me, this is not beneficial for me, this term is beneficial for me, this term, if I enter into this contract I will be at loss. Those kind of judgments if you can make properly, then you're of sound mind. Otherwise you're not of sound mind. Okay, if what does that mean? What type of judgments? These are known as rational judgments. What judgments? Rational judgments. Rational means what? Normal thinking people who are who can think normally, who can think about their benefits, who can think about their losses normally. Those people are known as rationally thinking people. Okay, so who are unsound mind people? Mental people, drunken people, who are under that alcohol influence. Can they understand anything properly? If you tell them, can they understand what is beneficial for them or not? Idiots. Idiots means what? Mental people. Okay. Here generally idiots. Idiots means the people who are whose minds are not generally. Whenever you talk to any person, you say, "Idiot, what are you doing?" But you know what is that you mean by that idiot word? Idiot means your mind is unstable from the very beginning, from your birth. When you were born, from that time only your mind is not working properly. You have some problem. Your mental state is not proper. Those people are known as idiots. Okay. So whenever you say someone this thing idiot, then you think that you're saying this, that you are mental from birth. Hmm? Another another word also you have. Other word. Yeah. Okay. And another thing is lunatics. Lunatics are those type of people who were at the time of their birth, they were stable, they had proper mental state, but as time passed, because of some problem, some accident, some problem, now their mind is not working properly. They are lunatics. So, lunatics, idiots, drunken people, all these people are considered to be people of unsound mind. They cannot think properly. They cannot make rational judgments. Those people are unsound mind people. So whenever you enter into contracts, those contracts should be entered only with sound mind people. Both the parties should have sound mind, then only valid, otherwise not valid. Why? Because a person of unsound mind is having no capacity to enter into contract, is having no ability to enter into contract as per law. Okay. Third category, not disqualified by law. Not disqualified by law. Persons should not be disqualified by law. Here, in this point, law only is giving you a list. These people, you cannot enter into contract. Why you cannot enter into contract? Because law is telling you. We are law and we are telling you, so you should not enter into contract. Say, for example, convicts. Convicts means what? Who are punished and who are undergoing punishment in prison for 10 years. In that 10 years, they are considered to be convicts. After that 10 years punishment is over, they can enter into contract. But for that 10 years, they are considered to be convicts. They cannot enter into contract. Likewise, insolvent people. Insolvent, you know who is an insolvent? Bankrupt. The people who go bankrupt. Their debts, liabilities are more than the assets they have. Whatever liabilities, whatever debts they are having is higher than the assets. Now you tell me, why do you think law said insolvents that you cannot enter into contracts? Why? Hmm? How, if they want to repay something, how can they repay it? Yes. See, now, as I told you this before also, if you enter into contract, both the parties are playing two roles. Yes or no? If I am a party to the contract, do I have any duty to perform? Do I have any benefit to enjoy also? Yes. So law is saying that already you are having so many liabilities, so many obligations, so many duties. You cannot take any more duty now. So therefore you cannot enter into contracts. If you enter into contract, then you will get the benefit. But with that benefit, will you get the duty also? Yes. Both the parties, I will get duty and benefit, you will also get duty and benefit. We are the parties to the contract. Yes or no? So that is the reason what is law saying? Insolvent, you are already having so many liabilities, so many things to do, so many duties to perform. Don't enter into any other contracts. Don't take any more liabilities. Don't take any more obligations. Okay? First fulfill your obligations what you have. That is the reason law said insolvents you cannot enter into contract. Anyways, this also we are going to see in your third unit in detail. The list also I am going to tell you. The list is given. That list also we are going to discuss. Just for your understanding, examples, I gave you two examples, convicts and insolvents. There's few more people which we are going to study afterwards. Okay, understood this point? Okay, capacity to contract. Who are the people who are having capacity to contract? The person who have attained the age of majority, the person who is of sound mind, person who is not disqualified by law. So these are the people who are having capacity to enter into contract, who are having the ability to enter into contract. Now you tell me, who are the parties who are not having capacity to enter into contracts? Majority, minors and unsound mind people, and who are disqualified by law. Clear? Yes or no? Okay. So actually whenever we are going to discuss this, we are going to discuss who are minors, who are unsound mind people, and who are disqualified by law. Apart from those, rest all are qualified. Rest all have capacity. But the list we are going to see, they are having no capacity. Okay. Next essential element to be present is lawful consideration and lawful object. Lawful consideration and lawful object. So what is law telling you? You are entering into contract. Consideration should be lawful, that is as per law, and your object also should be as per law. It should not be something which is against law. It should not be something which is against law. Something which is against law is what? Something which is considered to be illegal. It should be legal, that means it should not be illegal. Now you tell me, what is that you mean by consideration? Very good. Something in return. Something in return. So if I am entering into contract with you, something in return, whatever I am getting should be lawful. Otherwise not a valid contract. So for example, I am telling you, I will sell you my house, but in return you give me narcotics, drugs. You sell me drugs, you give me drugs. I will give you a house, in return you give me drugs. See, it is not always for money only. Contracts can be entered for things also. I will give you my old car, you give me your bike. Okay, that is also a contract, that is also a valid agreement. Okay, so here also I am telling you, I will give you my house. In return, what is that I want? Drugs. Is it valid? Is it legal? No. Is it a valid contract now? Why? Because here consideration, something in return, is illegal. Got this point clear? Object. What is the object of the contract? Is nothing but purpose. Purpose for which you are entering into contract. So, purpose for which, motive behind which you have entered into contract, that is your object of the contract. Say for example, I am telling you, I will pay you 10 lakh rupees, go and murder Mr. A. Go and murder Mr. A. So what is the purpose, what is the motive behind entering into contract? Murdering someone. Is it lawful? No. Therefore, is it a valid contract? No. I will pay you 5 lakh rupees, go and smuggle goods for me. Do smuggling for me. I will give you commission of 5 lakh rupees. So the motive, the object behind the contract is what? Smuggling of goods. Is it valid? Is it lawful? No, it is something which is illegal. Therefore, not a contract. Clear with this? Not a valid contract. It is just an agreement, not a contract. Clear with this? So in an agreement, always there has to be lawful consideration and lawful object. Then only it is going to be a valid contract. Not expressly declared void. What should not be expressly declared void here? Agreements. You have entered into an agreement expressly. Where it is expressed now? Expressed in a law. Any act. Any act. There are so many laws, there are so many acts. Not just contracts, sale of goods, partners. There are so many acts. You have SEBI, okay, that is you have security act, you have cyber laws, you have traffic laws, so many acts are there. In any act, if it is given, these kind of agreements should not be entered, it should not be entered. Expressly means what? It is clearly given in a act or in some law that you should not enter into these agreements. It is considered to be not an agreement. Say, I'll just, here also you have a list which you are going to see in your unit 3. But I'll just give you example, wagering agreements. What are wagering agreements? Wagering agreements are nothing but your betting agreements. You enter into betting contracts. If this happens, I will pay you this much. If this does not happen, you pay me. If India wins the match, I will pay you. If India does not win the match, you pay me. So all these are considered to be what? Wagering agreements. Wagering agreements are expressly declared not valid. Void here means what? Void is something which is not valid, something which is not enforceable. Something which is not enforceable. Something which is not enforceable, can it become a contract? No, it will just be an agreement. So these are considered to be therefore wagering agreements. They will never become contracts. Why? Because in India, wagering agreements are considered to be void. They are not not illegal. Void. Illegal only in the state of Gujarat and Maharashtra. It is not that illegal means what? Void and illegal ka difference we'll see. Types of contracts may void not enforceable but not punishable also. Illegal not enforceable as well as punishable. Usko illegal. Okay. So यहाँ पर wagering also we are going to see unit 3 in detail. In the state of Gujarat and Maharashtra, it is illegal wagering. Rest whole of India, it is only void, not enforceable by law. Okay. Clear with this everybody? Yes or no? So these are the 5 essential elements given under section 10. 5 essential elements which are given under section 10. So tell me fast, what are the 5 essential elements given under section 10? Proper offer, proper acceptance, free consent, capacity to contract, lawful consideration and lawful object, not expressly declared void. So did you understand all the 10 essential elements properly? Not given under section 10 and given under section 10 perfectly. Now tell me, not given under section 10. Two parties, what is the case law? Process Ramanlal S&N Company. And next one, intention to create legal relationship, case law Balfour versus Balfour. Next one, other formalities. Next one, certainty of meaning. Next, possibility of performance. Next, not given under section 10 now. Next, offer and acceptance, free consent, capacity to contract. Free consent? When are the agreements not considered to be under free consent? When there is coercion, when there is undue influence, when there is fraud, when there is misrepresentation and mistake. Okay, capacity to contract. Who are the parties who are capable of entering into contracts? Attain the age of majority, sound mind, not disqualified by law. Next, what is it? Lawful consideration and object and not expressly declared void. Clear with this? So these are the essential elements to be present in an agreement for it to become a contract. If these are present in the agreement, then only agreement is considered to be enforceable by law. So that enforceable by law should be read along with this 10. When it is enforceable by law, when these 10 things are present, enforceable by law. Any one thing is missing, not enforceable. Clear? Yes or no? Okay. Now, chalo. Now, let us now start another topic here. Types of contracts. Types of contracts. Now, let us see various types of contracts. Now, contracts are divided into three bases. Three bases. First one is based on validity. Based on validity, or you can say based on enforceability. Based on validity or based on enforceability. Another basis is what? Based on formation. Next is what? Based on formation, and then based on performance. So these are the three bases on which the contracts are divided. There are various types which we are going to see. Based on validity, you have valid contracts, you have void contracts, you have voidable contracts, you have illegal contracts, and you have unenforceable contracts. So what are the types you have? You have valid, void, voidable, illegal, unenforceable contracts. Based on your formation, again you have express contracts, implied contracts, quasi contracts, e-contracts. Okay, this is based on your formation. वो implied में आता है, I'll tell you. वो point आपको change करना है. You have to change that point. Okay. Based on performance, you have executed contracts and executory contracts. Again, under executory, you have unilateral and bilateral. Unilateral contracts and bilateral contracts. So these are the various bases on which contracts are divided. Okay, based on validity, based on formation, and based on performance. Let us see the first one now. Now let us start with the contracts, which are the types of contract based on validity, that is enforceability. How it is divided. First one is what? Valid contract. What is a valid contract now? The name itself is telling you valid contract is a contract where any contract which is enforceable by law is valid contract. So in this contract, what is to be present? All the essential elements, if they are present in any contract, it is considered to be what? Valid contract. Only if the essential elements are present, then only it is what? Enforceable. Once it is enforceable, it will become what? Valid. Valid contract. All the essential elements present in any contract is always considered to be a valid contract. Okay, that is a valid contract. How many essential elements are required to be present? 8, 7, 10. All the 10 to be present. Then only it will come under this category of contracts, valid contracts. Valid contract is normal contract. Enforceable by law, the contracts which we are talking about, those are valid contracts. Okay, next one. Void contracts. Void contract is defined under clause J of section 2. Void contract is defined under clause J of section 2. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So what is the definition given here? A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Clear? Understood? Obviously, it is a definition. Will you understand it properly? No. So, here the term ceases means what? Stop. To cease is to cease means to stop. And what is being stopped here? It is not being enforceable by law now. Not enforceable by law. That means you, whenever you entered into contract, you had support of law. Something happened because of which now you don't have support of law. It was valid, but after entering into contract and before performance of contract, understood? After entering but before performance of contract, something happened. Now the law is saying we will not support you. Say for example, if I am telling you, I will sell you 100 bottles of liquor. I will sell you 100 bottles of liquor. You pay me the price. Say 1 lakh rupees, you pay me for that. We entered into contract, it was valid. But in our area, government have banned now, what you say, dealings of liquors. You cannot purchase and sell liquors. You can do that only if you have that license. But I don't have license. Now, can I sell you liquor? Can you pay me the price? Is this valid now? No. But was that valid when we entered into contract? But now, will we have any support of law after that rule is passed? No. It was valid, but because of some event, now it has become void. Not enforceable by law. Why? Because now this has become illegal. No law. It is against law. Something which is against law, consideration or object against law, is it valid? That essential element, is it satisfied here? No, that is missing. Out of those 10, is that missing? Lawful consideration, lawful object, it is missing. Therefore, now it is not enforceable by law. Those type of agreements are considered to be what? Void agreements. Understood? Everybody, yes or no? So now tell me, in which section void agreement is discussed? Clause J of section 2. As per clause J, what is the definition? Becomes void when it ceases to be enforceable. Okay, it has not stopped being enforceable. It was, but now it has stopped being enforceable by law. Now under void, we have one more type of contract, No, under void I'm telling, no. Under void I am telling, no? Then that is void ab initio. What is that you mean by void ab initio? Ab initio means what? From the very beginning. From the very beginning. From the very beginning. That means the example which I just now gave you was for that. It was valid, but afterward it became void. But here, from the very start, it is void. That means any one essential element is missing from very start. Say for example, I am telling you, I will pay you 5 lakh rupees, go to Sky and get stars for me. Is it valid? Will you have support of court? When we are entering into contract, from that time only it is what? Void. These type of contracts are what? Void ab initio contract. They also come under void only. They are a part of void contracts. So under void contracts, we have two type of contracts. Contracts which were very much valid, but afterwards it became void. Those are also void. And contracts which are void from very beginning, that is nothing but void ab initio contract. Any one of the essential or two or three essential elements are missing from the very beginning of the contract. Void contract, no support of law, not enforceable by law, are considered to be void contracts. Understood? Valid contract and void contract. Yes or no? Yes or no? Okay. Next. Third type of contract is what? Voidable contract, which is defined in which section? Clause I of section 2 is defining your voidable contract. As per this, what is a voidable contract? An agreement which is enforceable by law at the option of one or more parties, but not at the option of other or others. Those type of contracts are voidable contracts. Understood? Obviously. Why? Because which term? Legal term cannot be understood properly. There are two parties, A and B. A is having a house which he wants to sell it to B for say 20 lakh rupees. Okay. Already B is having three houses. Does he require any house now? No, he does not want to purchase any house. But what is he saying? You will have to purchase the house, otherwise I will kill you. You will have to purchase my house. Give me 20 lakh rupees. And otherwise, what will I do? I will kill you. This type of contract is entered into under coercion. Any contract which is entered under coercion, undue influence, fraud, misrepresentation, only these four, not mistake. Only the mistake always void. You are at fault, not the other party. Void, no support of court. But contract entered under coercion, undue influence, when some other party is doing something wrong with you. Is there any fault? Your fault? No, no. This law is saying that we will support you. But we will not support the party who is at mistake, who is wrong. We will not support that party. Got this point clear? So, under coercion, if there is any contract entered, these type of contracts are always considered to be what? Voidable contracts. Contracts which are enforceable at the option of one or more parties, but not at the option of other or others. Now, what is that you mean at the option of one or more parties? That means now there are two parties here. One party is known as defaulting party. Defaulting party means what? Who is doing the wrong here. Another party is known as what here? Aggrieved party. That means the party who is suffering. Suffering party. Yes. So here in our example, who is doing wrong here? So he is known as what party? Defaulting party. And the party on whom this wrong is done, who is suffering because of this wrong, is B. This person is known as which party? Aggrieved party. Aggrieved party, or you can say suffering party also. aggrieved party or suffering party. Now, as per the definition of voidable contract, a contract which is enforceable at the option of one or more parties but not at the option of other or others. Here law is saying that B, because you are a suffering party, we are giving you two options. Either you can say yes to the contract or you can say no to the contract. Now you must be getting it out. Already he has said a yes. Why? Because there was a gun or there was some knife or something where I got the person is being threatened to be killed. So obviously he has said a yes here. But was that yes valid? No, it was without any use. I mean, it was without any significance, without any importance. That yes had no validity. Why? Because was there any free consent there? No. So now court is saying that now it is your wish. You can say yes, yes, I will purchase the house, I want the house, or you can say no, no, you take your house and give me my 20 lakh rupees again. So to make this contract valid or to make this contract void, who is having the option? The aggrieved party. So what is a voidable contract here? Which is enforceable, which can be made valid at the option of one or more parties. There can be 2-3 parties who are being, say the house is in the name of 3 people. Okay, I have threatened all the 3 that I will murder all the 3. You transfer that property in my name, or say I want to sell the property to 3 people together. What will I say? You purchase the property, or else I'll kill all the 3. So there can be one party, or there can be more parties also to a contract. I told you this before also. At least 2 parties, but can there be more? Yes, that is the reason what is used here, which is enforceable at the option of one party or more, any one party or more. That means B or any other people, maybe if he wants to sell. Okay, so it is at the option of aggrieved party. If he wants, he can keep the house with himself, make the contract valid, tell that okay, okay, no problem, though you have threatened me, but now house is very nice, I want to keep the house. Okay, or his else what is that he can say, I don't want this house, you did wrong to me, I will go to court of law. He is going to court of law, he is telling court of law that no, no, I don't want the house, I want my 20 lakh rupees back. So he can make it valid or he can make it void. So this option is given to the aggrieved party. Got this point here? These type of contracts are known as what contracts? Voidable contracts. So what is a voidable contract? Contract which is enforceable at the option of one or more parties. Who is this one or more parties? Aggrieved party. Aggrieved party. And not enforceable at the option of other or others. At the option of one or more parties. Here this one or more party is who? Aggrieved party. And not at the option of other or others. This other or others is who? Defaulting party. Defaulting party, you cannot do anything. If this aggrieved party says yes, you will have to agree to it. If this aggrieved party says no, you will have to agree to it. You don't have any option. Who is having no option? Defaulting party. Clear? Everybody, this is very, very important. Why? Because when we study this coercion and influence, you are going to study this. You have to have this knowledge of voidable contract. Is there any doubt? Voidable contract? Okay. Anyways, if you have any doubt, you can always clarify with me. Okay. Before class or after class, as I told you before. So now for today, we are going to stop here. Tomorrow, we are going to continue again. Okay. So what is that we have done today? We have done essential elements of valid contract. Very, very important that is. And in types of contract, under based on validity, we have seen 3 types. So what are those 3 types? Valid contracts we have seen, void contracts we have seen, and voidable contracts we have seen. So I want everyone to go home and please read everything that we have discussed. And if you have any doubt, please clarify with me. Okay, before class, after class, and virtual students also, you can clarify with me through messages. Okay, clear with this? Okay.